Now, I'm giving y'all a copy of your jury instructions. Let me ask you this, though, to make sure. You remember my instructions before? We've talked about it several times. We're not supposed to talk to each other about the case until we've gotten all the law and all the facts and all that. So everybody agrees with me that you do not speak to each other or anybody else about this case last night while y'all were gone. Everybody just raise your hand on that. Thank you very much. So today what I'm going to do is, by law, I've got to read you these instructions. So, and I read pretty fast, which is a problem. So if I skip a word, you need to go by what's in this document, not by my speaking. And if I mess up the pronunciation of a word, which I'll do sometime, go by what's in the written document. And you don't have to follow along. You'll get to take this back there with you when you begin your liberation, but whatever makes you comfortable. Some people are better learn more from listening. Some people are better from reading, so it's just kind of up to y'all. Everybody understand that? So as I read this to you, I'm not sure how long it'll take, but if you need to take a break as we're going through this for a bathroom break, just raise your hand and I'll stop what I'm doing. Deal? Okay. All right. Let's get started on this. The defendant, Shannon Finnegan, is charged in indictment C1C0051A with the crimes of first-degree premeditated murder, first-degree felony murder, aggravated rape, aggravated kidnapping, especially aggravated kidnapping, abuse of the corpse, and tampering with evidence. Count 1 charges the defendant with the offense of first-degree premeditated murder of Jennifer Paxton. The offense necessarily includes the lesser offenses of facilitation of first-degree premeditated murder, second-degree murder, facilitation of second-degree murder, voluntary manslaughter, facilitation of voluntary manslaughter, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, and facilitation of criminally negligent homicide. Counts 2 and 3 charge the defendant with the offense of first-degree felony murder of Jennifer Paxton by alternative means. Count 2 charges felony murder during the perpetration of or attempt to perpetrate aggravated kidnapping. And count 3 charges felony murder during the perpetration of or attempt to perpetrate aggravated rape. Each of these offenses necessarily includes the lesser offenses of facilitation of first-degree felony murder, second-degree murder, facilitation of second-degree murder, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, and facilitation of criminally negligent homicide. Counts 4, 5, and 6 charge the defendant with the offense of aggravated rape. Each of these offenses necessarily include the lesser offenses of attempted aggravated rape, facilitation of aggravated rape, aggravated sexual battery, attempted rape, facilitation of rape, attempted aggravated sexual battery, facilitation of aggravated sexual battery, facilitation of attempted aggravated rape, facilitation of attempted rape, facilitation of attempted aggravated sexual battery, attempted sexual battery, and facilitation of sexual battery. Count 7 charges the defendant with the offense of aggravated kidnapping. This offense necessarily includes the lesser offenses of attempted aggravated kidnapping, facilitation of aggravated kidnapping, attempted kidnapping, facilitation of kidnapping, facilitation of attempted aggravated kidnapping, facilitation of attempted kidnapping, false imprisonment, and attempted false imprisonment. Count 8 charges the defendant with the offense of especially aggravated kidnapping. This offense necessarily includes the lesser offenses of attempted especially aggravated kidnapping, facilitation of especially aggravated kidnapping, attempted aggravated kidnapping, facilitation of aggravated kidnapping, facilitation of attempted especially aggravated kidnapping, attempted kidnapping, facilitation of kidnapping, facilitation of attempted aggravated kidnapping, facilitation of attempted kidnapping, false imprisonment, and attempted false imprisonment. Count 9 charges the defendant with the offense of conspiracy to commit first-degree premeditated murder. This offense necessarily includes the lesser offenses of conspiracy to commit second-degree murder and conspiracy to commit voluntary manslaughter. Count 10 charges the defendant with the offense of conspiracy to commit aggravated rape. The offense necessarily includes the lesser offenses of conspiracy to commit rape, conspiracy to commit aggravated sexual battery, and conspiracy to commit sexual battery. Count 11 charges the defendant with the offense of conspiracy to commit aggravated kidnapping, This offense necessarily includes the lesser offenses of conspiracy to commit kidnapping and conspiracy to commit false imprisonment. Count 12 charges the defendant with the offense of abuse of a corpse. This offense necessarily includes the lesser offense of attempted abuse of a corpse and facilitation of abuse of a corpse. And count 13 charges the defendant with the offense of tampering with evidence. The offense necessarily includes the lesser offense of attempted tampering with evidence, facilitation of tampering with evidence, and facilitation of attempted tampering of evidence. The defendant pleads not guilty to each and every offense embraced in the indictment. The evidence in this case has been completed, and it is my duty to now instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of others, or others, but should consider each one in light of and in harmony with the others. Whenever a singular of a word is used in these instructions, it may be taken equally to mean plural. Wherever the word he is used in these instructions, you may consider it as applying equally to a woman or an entity such as a corporation. The indictment in this case is the formal written accusation charging the defendant with these crimes. It is not evidence against the defendant and does not create any inference of guilt. At times during the trial, I've ruled upon the admissibility of evidence. You must not concern yourself with these rulings, neither by such rulings, these instructions, or nor any remarks which I have made do I mean to indicate any opinion as to the facts or what your verdict should be. Statements, arguments, or remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. You are the exclusive judges of the facts in this case, and also you are the exclusive judge of the law or the direction of the court. You should apply the law or the facts and assign the case. You should consider all the evidence in the light of your own observations and experience in life. You as jurors must decide the case based solely on the evidence presented to you within the four walls of this courtroom. This means that during the trial, you must not conduct any independent research about this case, the matters in the case, and the individuals involved in the case. In other words, you should not consult dictionaries or reference materials, search the internet, websites, blogs, use any other electronic tools to obtain information about the case or to help you decide the case. Please do not try to find out any information from any source outside the confines of this courtroom. Until you retire to deliberate, you may not discuss the case with anyone, even your fellow jurors. After you retire to deliberate, you may begin discussing the case with your fellow jurors, but you cannot discuss the case with anyone else until you've returned a verdict in the case is at an end. I hope that for all of you, this case is interesting and noteworthy. I know that many of you have used cell phones in the past, Blackberries, the internet, and other tools of technology. You also must not talk to anyone else about the case or use these tools to communicate electronically with anyone in the case. This includes both your family and friends. You may not communicate with anyone about the case on your cell phone, through email, Blackberry, iPhone, text message, or on Twitter or X, through any blog or website, through any internet chat room, or by way of any other social networking website, including but not limited to Facebook, MySpace, LinkedIn, and YouTube. The law presumes the defendant is guilty of the charges against him. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial, and is not overcome unless from all the evidence in the case you're convinced beyond reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts, but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all the proof in the case, and inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of the proof necessary to constitute the offense. During the trial, many of you have taken notes concerning the evidence presented in court.
These notes are simply to assist you in remembering what transpired in court. Your notes are not evidence or a transcript of the testimony. They are not a substitute for your recollection of your evidence that you saw or you heard in court. You may use your particular notes during deliberations to the extent you think they are helpful, but the fact that a particular juror has taken notes does not mean that that juror's views should be given any greater weight than those of any other juror. The state must have proven beyond a reasonable doubt all the elements of the crime charged, and that was committed before the finding and returning of the indictment in this case. The burden is upon the state to prove by preponderance of evidence this offense was committed in Anderson County, Tennessee. Proof by preponderance of evidence means that the greater weight of evidence must be in support of the state's contention. Venue of the offense lies where the offense was commenced or consummated. If you find the state has failed to prove by preponderance of evidence that this offense was commenced or consummated in Anderson County, Tennessee, then you must return a verdict of not guilty. The defendant is criminally responsible as a party to the offenses of first-degree premeditated murder, first-degree felony murder, aggravated rape, aggravated kidnapping, especially aggravated kidnapping, abuse of the corpse, and or tampering with evidence. If the offenses were committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both, each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense, or to the benefit of the proceeds or results of the offense, the defendant direct, aids, or attempts to aid another person to commit the offense. A defendant who is criminally responsible for an offense may be found guilty not only of that offense, but also for any other offense or offenses committed by another, if you find beyond a reasonable doubt that the other offense or offenses committed were natural and probable consequences of the original offense for which the defendant is found criminally responsible, and that the elements of the other offense or offenses that accompanied the original offense have been proven beyond a reasonable doubt. With regards to count 2 and 3, charging the defendant with murder and perpetration of aggravated rape and aggravated kidnapping, respectively, this natural and probable consequences rule does not apply. There is no requirement that the killing be foreseeable in order to hold the defendant criminally responsible, only that the defendant intended to commit the alleged aggravated rape and aggravated kidnapping, respectively. To find a defendant criminally responsible for the acts of another, it is not necessary that you find that the defendant was present or that the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of the offense is not sufficient to support a conviction. Before you find the defendant guilty of being criminally responsible for said offenses committed by the conduct of another, you must find all the essential elements of said offense have been proven by the state beyond a reasonable doubt. Facilitation of felony. Any person who commits the offense of facilitation of felony is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit the specific felony, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense. And 2, that the defendant furnished substantial assistance to that person in the commission of the felony. And 3, that the defendant furnished such assistance knowingly. Here, knowingly means that person acts knowingly with respect to the conduct or the circumstances surrounding the conduct, when the person is aware of the nature of the conduct or the circumstance exists. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Here, intent means that the person acts intentionally with respect to the nature of the conduct or to the result of the conduct when the person's conscious objective or desire to engage in the conduct or cause the result. Criminal attempt. Any person who attempts to commit a criminal offense is guilty of a crime. If we define a person guilty of criminal attempt, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense, and 2, that the defendant did some act intending to complete a course of action or cause a result that would constitute the offense or the circumstances as the defendant believed them to be at the time, as actions constitute a substantial step towards the commission of the offense. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit the offense. Here, intending, and intent means that the person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it's the person's conscious objective or desire to engage in the conduct or cause the result. The essential elements necessary to constitute an offense, which intent is a lesser included offense, are set out within these instructions on that offense. Count 1, first degree premeditated murder. Any person who commits the offense of first degree premeditated murder is guilty of a crime. If we find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, the defendant unlawfully killed the alleged victim. And 2, the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. And 3, the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement or passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. If you find from the proof beyond a reasonable doubt the defendant is guilty of premeditating the first-degree murder, then it is your duty, after a separate sentencing hearing, to determine whether the defendant will be sentenced to death, life imprisonment without possibility of parole, or life in prison. But you will not consider punishment for this offense at this time. If you find from the proof beyond a reasonable doubt that the defendant is guilty of first-degree premeditated murder, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of first-degree premeditated murder as charged during the indictment, then your verdict must be not guilty as this offense, and then you will proceed to determine his or her guilt or his guilt or innocence of facilitation of first-degree premeditated murder, a lesser included offense. And this too will be listed on the verdict form. The essential elements necessary to constitute facilitation of a felony and premeditated first-degree murder have previously been set out in these instructions. If you find from the proof beyond a reasonable doubt the defendant guilty of facilitation of first-degree premeditated murder, you shall so report on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of first-degree premeditated murder as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of second-degree murder, a lesser included offense. The lesser included offense of second-degree murder. A person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1, the defendant unlawfully killed the alleged victim, and 2, the defendant acted knowingly. Knowingly means a person acts with awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means a person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. The distinction between voluntary manslaughter and second degree is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. If you find from the proof beyond a reasonable doubt that the defendant is guilty of second-degree murder, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of second-degree murder as charged in the indictment, then your verdict must be not guilty as this offense, and then you shall proceed to determine the guilt or innocence of facilitation of second-degree murder, a lesser included offense. The essential elements necessary to constitute facilitation of felony or second-degree murder have previously been set out in these instructions. Refer to these instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of second-degree murder, you will so report that on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of second-degree murder as charged in the indictment, then your verdict must not only be as to the offense, then you shall proceed to determine his guilt or innocence of voluntary manslaughter, a lesser included offense. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1, the defendant unlawfully killed the alleged victim, and 2, the defendant acted intentionally or knowingly, and 3, the killing resulted from the state of passion produced by an adequate provocation sufficient to lead to a reasonable person to act in an irrational manner. Again, the distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Intentionally and knowingly have been defined for you in instruction on second-degree murder. Please refer to those definitions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of voluntary manslaughter, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of voluntary manslaughter as charged in indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of voluntary manslaughter as a lesser included offense. Facilitation of voluntary manslaughter. The essential elements necessary to constitute facilitation of a felony and voluntary manslaughter previously have been set out in these instructions. Refer to these instructions here. If you find from the proof that beyond a reasonable doubt that the defendant is guilty of facilitation of voluntary manslaughter, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of voluntary manslaughter as charged in this indictment, then your verdict must be not guilty as to this offense, and then you shall not proceed to determine his guilt or innocence of. Then you shall proceed to determine his guilt or innocence of reckless homicide, a lesser included offense. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, the defendant killed the alleged victim, and 2, the defendant acted recklessly. Recklessly means that a person acts recklessly when a person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. Intentionally or knowingly have previously been defined for you in instructions on second-degree murder. Please refer to those definitions here. If you find beyond a reasonable doubt the defendant guilty of reckless homicide, you will so report on your verdict form. If you have found a reasonable doubt as to the defendant's guilt of reckless homicide as charged in indictment, then your verdict must be not guilty as to those offenses, and then you shall proceed to determine his guilt or innocence of facilitation of reckless homicide, a lesser included offense. Facilitation of reckless homicide. The essential evidence necessary to constitute facilitation of a felony and reckless homicide proofs have been set out in these instructions. Refer to those instructions here. If you find from your proof beyond a reasonable doubt that the defendant is guilty of facilitation of reckless homicide, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of reckless homicide as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of criminally negligent homicide, a lesser included offense. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, the defendant's conduct results in the death of the alleged victim, and 2, the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unsubstantial risk, unjustifiable risk, substantial and unjustifiable risk that the alleged victim will be killed. The risk may be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person will exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. Intentionally and knowingly are defined these instructions on the second-degree murder. Recklessly is defined these instructions on reckless homicide. Refer to those definitions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of criminally negligent homicide, you will so report that your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of criminal negligent homicide as charged in this indictment, then your verdict must be guilty as to this offense. And then you shall proceed to determine if his guilt or innocence of facilitation of criminally negligent homicide, a lesser included offense. The essential elements of necessary to constitute facilitation of a felony and criminally negligent homicide have previously been set out in these instructions. Refer to those instructions here. If from your proof beyond a reasonable doubt that the defendant is guilty of facilitation of criminally negligent homicide, you will so report your verdict on the verdict form. If you have found a reasonable doubt as to the defendant's guilt on the facilitation of criminally negligent homicide as charged, then your verdict must be not guilty as to this offense. Counts 2 and 3. First-degree felony murder. Any person who commits first-degree felony murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant or one for whom the defendant is criminally responsible unlawfully killed the alleged victim. And 2, the killing was committed in the perpetration of the attempt to perpetrate the alleged aggravated kidnapping, count 2, or the alleged aggravated rape, count 3, and that the killing was closely connected to the alleged aggravated kidnapping, count 2, or aggravated rape, count 3, and was not a separate, distinct, independent event. And 3, the defendant intended to commit the alleged aggravated kidnapping on count 2 or the aggravated rape on count 3. Aggravated kidnapping and aggravated rape are defined for you within these instructions. Refer to these instructions and definitions herein. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Considerations of such facts are as time, place, causation, is helpful in determining whether a killing was committed in the perpetration of the alleged aggravated kidnapping, count 2, or aggravated rape, count 3. The killing may have preceded, conceived with, or followed the aggravated kidnapping, count 2, or aggravated rape, count 3, and still be considered as occurring in the perpetration of the aggravated kidnapping, count 2, or aggravated rape, count 3, so long as there is a connection in time, place, and continuity of action. When one enters into a scheme with another to commit aggravated kidnapping, count 2, or aggravated rape, count 3, and death ensues, both defendants are responsible for the death regardless of who actually committed the killing and whether the killing was specifically contemplated by the other. Here, intentionally means that the person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. If you find from the proof beyond a reasonable doubt that the defendant is guilty of first-degree felony murder, then it shall be your duty after a separate sentencing hearing to determine whether the defendant will be sentenced to death, life imprisonment without the possibility of parole, or life in prison. But you will not consider the punishment for this offense at this time. If you find from the proof beyond a reasonable doubt the defendant is guilty of first-degree felony murder, you will so report that on your verdict form. If you have a reasonable doubt as to the defendant's guilt of first-degree felony murder as charged in the indictment, then your verdict must be not guilty of this offense, and then you shall proceed to determine his guilt or innocence of facilitation of first-degree felony murder as a lesser included offense. The essential elements necessary to constitute facilitation of felony and first-degree felony murder have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of first-degree felony murder, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of first-degree felony murder as charged in this indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of second-degree murder, a lesser included offense. The essential elements necessary to constitute second-degree murder have previously been set out in these instructions, and lesser offenses of count 1. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of second-degree murder, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of second-degree murder as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence in facilitation of second-degree murder, a lesser included offense. The essential elements necessary to constitute facilitation of a felony and second-degree murder have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of second-degree murder, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of second-degree murder as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of reckless homicide, a lesser included offense. The essential elements necessary to constitute reckless homicide have previously been set out in these instructions. In the lesser offenses of count 1, refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of reckless homicide, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of reckless homicide as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of reckless homicide, a lesser included offense. The essential elements necessary to constitute facilitation of felony and reckless homicide have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of reckless homicide, you shall so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of reckless homicide as charged in the indictment, then your verdict must be not guilty as this offense, and then you should proceed to determine his guilt or innocence of criminally negligent homicide, a lesser included offense. The essential elements necessary to constitute criminally negligent homicide have previously been set out in these instructions. In the lesser offenses of count 1, refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of criminally negligent homicide, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of criminally negligent homicide, as charged in the indictment, then your verdict must be guilty as to this offense, and then you shall proceed. Let me read that again. If you have a reasonable doubt as to the defendant's guilt of criminally negligent homicide as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of criminally negligent homicide, a lesser included offense. The essential elements necessary to constitute facilitation of a felony and criminally negligent homicide have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of criminally negligent homicide, you will so report on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of criminally negligent homicide as charged in the indictment, then your verdict must be not guilty as to this offense. Counts 4, 5, and 6, aggravated rape. Any person who commits the offense of aggravated rape is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, the defendant had unlawful sexual penetration of the alleged victim, or the alleged victim had unlawful sexual penetration of the defendant. And 2, as to count 4, force was used to accomplish the act as the defendant was armed with a weapon or any article used or fashioned in a manner to lead the victim reasonably to believe to be a weapon, to wit, a baseball bat. Or B, as to count 5, the defendant caused bodily injury to the alleged victim. Or as to count 6, the defendant was aided or abetted by one or more persons and that force was used to accomplish the act. And 3, the defendant acted either intentionally, knowingly, or recklessly. An aider or abettor is one who advises, counsels, or procures, or encourages another to commit a crime. Bodily injury includes a cut, abrasion, bruise, burn, or figment, or physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Force means the compulsion by the use of any physical power or violence. Sexual penetration means sexual intercourse, cunnilingus, fellatio, anal intercourse, or any other intrusion, however slight, of any other person, part of any person's body, or any object into the genitalia or anal opening of the alleged victim, the defendant's, or any other person's body, but the emission of semen is not required. Cunnilingus means a sex act accomplished by placing the mouth or tongue on or in the vagina of another. Fellatio means a sex act accomplished with the male sex organ and the mouth or lips of another. Intrusion of the alleged victim's mouth is not required. Victim means the person alleged to have been subjected to the criminal sexual conduct. Here, intentionally means a person's act intentionally with respect to the nature of the conduct or as a result of the conduct, when it's the person's conscious objective or desire to engage in the conduct or cause a result. Here, knowingly means a person acts knowingly with respect to the conduct or the circumstances surrounding the conduct, when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to be the result. Here, recklessly means a person acts recklessly with respect to the circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstance exists or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances is viewed from the accused person's standpoint. Election of offenses. The state has offered proof in this case in chief of more than one alleged committed offense committed by the defendant in or by one. Let's start that over. The state has offered proof in its case in chief of more than one act allegedly committed by the defendant or by one for whom the state alleges the defendant is criminally responsible, which the state alleges constitute an element of the offense of aggravated rape as charged in counts 4 and 5 and 6 of the indictment. To ensure a unanimous verdict, the law requires the state to elect which alleged act testified to the state that the state is relying upon for your consideration in deciding whether or not the defendant is guilty of the offense or any lesser included offense. The fact that the court has required the state to elect does not mean the court has found that the state has carried its burden of proving those allegations beyond reasonable doubt. That is for your determination. In this case, the state has elected to submit for your consideration as to count 4, the alleged act where Jennifer Paxton was hit with a baseball bat and forced to perform fellatio on Sean Finnegan. Members of the jury are to consider only this alleged act and decide whether or not the defendant has been proven guilty beyond a reasonable doubt of the offenses in and charged in count 4. In this case, the state has elected to submit for your consideration as follows in count 5. The alleged act where Sean Finnegan sexually penetrated Jennifer Paxton with sex toys in the vagina of Jennifer Paxton, and Jennifer Paxton suffered bodily injury, to wit, bruising about her head, chin, arms, hips, and legs. Members of the jury are to consider only this alleged act and decide whether or not the defendant has been proven guilty beyond a reasonable doubt of the offenses charged in count 5. In this case, the state has elected to submit for your consideration as follows in count 6. The alleged act where Sean Finnegan is present when Rebecca Dishman had sex with Jennifer Paxton, and Sean Finnegan then received fellatio from Rebecca Dishman. Members of the jury are to consider only this alleged act and decide whether or not the defendant has been proven guilty beyond a reasonable doubt of the offenses and charge included in count 6. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated rape, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of aggravated rape as charged in the indictment, then your verdict must be not guilty as to this offense, and then you will proceed to determine his guilt or innocence of attempted aggravated rape, a lesser included offense. The essential elements necessary to constitute attempt and aggravated rape have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of attempted aggravated rape, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of the attempted aggravated rape as charged in the indictment, then your verdict must be not guilty of this offense, and then you should proceed to determine his guilt or innocence of facilitation of aggravated rape, a lesser included offense. Facilitation of aggravated rape. The essential elements necessary to constitute facilitation of a felony and aggravated rape have previously been set out in these instructions. Refer to those instructions herein. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of aggravated rape, you will so report on your verdict form. You'll so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of aggravated rape as charged in the indictment, then your verdict must be not guilty of this offense, and then you should proceed to determine his guilt or innocence of rape, a lesser included offense. Rape. Any person who commits the offense of rape is guilty of a crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1. Defendant had unlawful sexual penetration of the alleged victim, or the alleged victim had unlawful sexual penetration of the defendant. And 2, that force was used to accomplish the act. And 3, the defendant acted either intentionally, knowingly, or recklessly. Intentionally, knowingly, recklessly were all defined for you in the instruction on aggravated rape. Refer to those instructions here. If you find from your proof beyond a reasonable doubt that the defendant is guilty of rape, you should so report on your verdict form. If you have a reasonable doubt as to the defendant's guilt of rape as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of aggravated sexual battery, a lesser included offense. Aggravated sexual battery. A person who commits the offense of aggravated sexual battery is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proved beyond the essential elements. 1, as to count 5, the defendant had intentional unlawful sexual contact with the alleged victim, in which the defendant intentionally touched the alleged victim's intimate parts or clothing covering the immediate area of the alleged victim's intimate parts. Or B, as to counts 4 and 6, the alleged victim had intentional lawful sexual contact with the defendant, in which the victim intentionally touched the defendant or any other person's intimate parts or clothing covering the immediate area of the defendant's or any other person's intimate parts. And 2A, as to count 4, the defendant intentionally, knowingly, or recklessly used force to accomplish the act and was armed with a weapon or any article used or fashioned in a manner to lead the alleged victim reasonably to believe it to be a weapon, to wit, a baseball bat. Or B, 2B, as to count 5, the defendant intentionally, knowingly, or recklessly caused bodily injury to the alleged victim. Or, as to count 6, the defendant was aided or abetted by one or more persons and intentionally, knowingly, or recklessly used force to accomplish this act. Bodily injury, force, victim, intentionally, knowingly, recklessly were defined for you in these instructions on aggravated rape. Refer to those definitions here. Intimate parts include semen, vaginal fluid, primary genitalia area, groin, inner thigh, buttocks, or breast of a human being. Sexual conduct means the intentional touching of the alleged victims, the defendant, or any other person's intimate parts, or the intentional touching of the clothing covering the immediate area of the alleged victim, the defendant, or any other person's intimate parts. If that intentional touching can be reasonably construed as being for the purpose of sexual arousal or gratification. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated sexual battery, you will so report your verdict on your verdict form. And if you have a reasonable doubt as to the defendant's guilt of aggravated sexual battery as charged in the indictment, then your verdict must be not guilty as to the offense, and then you should proceed to determine his guilt or innocence of attempted rape, a lesser included offense. Attempted rape. The essential elements necessary to constitute attempt and rape have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of attempted rape, you will so report your verdict on your attempted verdict form. If you have a reasonable doubt as to the defendant's guilty of attempted rape as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine the guilt or innocence of facilitation of rape, a lesser included offense. The essential elements necessary to constitute facilitation of a felony and rape have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of rape, you will so report on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of rape as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of attempted aggravated sexual battery, a lesser included offense. Attempted sexual battery. The essential elements necessary to constitute attempted and aggravated sexual battery have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of attempted aggravated sexual battery, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of attempted aggravated sexual battery as you charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of facilitation of aggravated sexual battery, a lesser included offense. The essential elements necessary to constitute facilitation of a felony and aggravated sexual battery have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of aggravated sexual battery, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of aggravated sexual battery as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of facilitation of attempted aggravated rape, a lesser included offense. The essential elements necessary to constitute facilitation of a felony, attempt, and aggravated rape have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt the defendant is guilty of facilitation of attempted aggravated rape, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt or facilitation of attempted aggravated rape as charged in the indictment, then your verdict must be not guilty of this offense, and then you're to proceed to determine guilty or innocent of facilitation of attempted rape, a lesser included offense. The essential elements necessary to constitute a facilitation of a felony, attempted rape have previously been set out in these instructions. Refer them to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of attempted rape, you shall so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of attempted rape as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of attempted aggravated sexual battery, a lesser included offense. Facilitation of attempted aggravated sexual battery. The essential elements necessary to constitute facilitation of a felony, attempted aggravated sexual battery have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of attempted aggravated sexual battery, you report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of attempted aggravated sexual battery as the charge in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of sexual battery, a lesser included offense. Sexual battery. Any person who commits the offense of sexual battery is guilty of a crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1, as to count 5, the defendant had intentional or unlawful sexual contact with the alleged victim in which the defendant intentionally touched the alleged victim's intimate parts or the clothing covering the immediate area of the alleged victim's intimate parts. Or B, as to counts 4 and 6, the alleged victim had intentional or unlawful sexual conduct with the defendant in which the victim intentionally touched the defendant's or any other person's intimate parts or the clothing covering the immediate area of the defendant's or any other person's intimate parts. And 2, force was used to accomplish the act. And 3, the defendant acted either intentionally, knowingly, or recklessly. Force, intimate parts, sexual conduct, victim, intentional, knowing, and recklessly were defined for you in these instructions on aggravated rape and aggravated sexual battery. Refer to those definitions here. If you find from your proof a reasonable doubt that the defendant is guilty of sexual battery, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of sexual battery is charged in the indictment, then your verdict must be not guilty as to this offense. And then you'll proceed to determine his guilt or innocence of attempted sexual battery, a lesser included offense. The essential elements necessary to constitute attempted sexual battery have been previously set out in these instructions. Refer to those instructions here. If you find from the proof that beyond a reasonable doubt that the defendant is guilty of attempted sexual battery, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilty of attempted sexual battery as charged in the indictment, then you must return a verdict of not guilty as this offense, and then you shall proceed to determine the guilt or innocence of facilitation of sexual battery, a lesser included offense. Facilitation of sexual battery. The essential elements necessary to constitute facilitation of a felony and sexual battery have been previously set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of sexual battery, you shall report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of sexual battery is charged, then your verdict must be not guilty as to this offense. Okay, nobody need a break? Still good? Okay. Aggravated kidnapping, count 7. Any person who commits an aggravated kidnapping is guilty of a crime. We the following essential elements. 1, the defendant knowingly removed or confined another unlawfully so as to interfere substantially with the other person's liberty. And 2, the defendant did so to facilitate the commission of aggravated rape. The essential elements necessary to constitute aggravated rape are previously set out in these instructions. A removal or confinement of fraud. Force means compulsion by the use of physical power or violence. Fraud is defined as this term is used in the ordinary conversation and includes, but is not limited to, deceit, trickery, misrepresentation, and subterfuge. Violence means evidence of physical force unlawfully exercised so as to damage, injure, or abuse. Physical contact is not required to prove violence. The definitions of knowingly, and then you shall proceed to determine his guilt or innocence of attempted false imprisonment, a lesser included offense. Attempted false imprisonment, kidnapping. The essential elements necessary to constitute the attempted false imprisonment have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt the defendant is guilty of attempted false imprisonment, you will so report your verdict on your verdict form. If you find a reasonable doubt as to the defendant's guilt of attempted false imprisonment as charged in the indictment, then your verdict must be not guilty as to this offense. I'm going to stand up for me. Anybody need to stand up?
Yep.
Everybody good? Okay. So if I stand up while I'm talking, that's okay. All right?
You got a yes, Judge.
Yeah, I understand.
Yes, stand up. If we could exercise, we could do some stretches and stuff like that. All right, count 8. Especially aggravated kidnapping. Any person who commits a special aggravated kidnapping is guilty of a crime. We find the defendant guilty of this offense, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1, the defendant knowingly removed or confined another unlawfully so as to interfere substantially with the other's liberty. And 2, the confinement or removal was accomplished with a deadly weapon or by display of any article used or fashioned to lead the alleged victim to reasonably believe it was a deadly weapon, to wit, a baseball bat. A removal or confinement is unlawful if it's accomplished by force, threat, or fraud. Force and fraud are defined for you in the instruction on aggravated kidnapping, count 7. Please refer to those definitions here. Here, violence means the evidence of physical force unlawfully exercised so as to damage, injure, or abuse. Physical contact is not required to prove violence. Unlawfully pointing a deadly weapon at an alleged victim is physical force directed toward the body of the victim. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. The definitions of bodily injury, knowingly and intentionally, have previously been defined for you in these instructions on aggravated rape. Refer to those instructions herein. Although the law requires no specific period of time of confinement or distance of removal or confinement interferes substantially with another's liberty if the time of confinement is significant or the distance of removal is considerable. To find the defendant guilty of this offense, the aggravated kidnapping, you must also find beyond a reasonable doubt that the removal or confinement was to a greater degree than necessary to commit the offenses of premeditated first-degree murder, felony murder, count 3 only. Aggravated rape is charged in counts 1, 3, 4, 5, and 6. And in making this determination, you may consider all the relevant facts and circumstances of the case, including but not limited to the following factors. A, nature and duration of the alleged victim's removal or confinement by the defendant. B, whether the removal or confinement occurred during the commission of the separate offense. C, whether the interference with the alleged victim's liberty was inherent in the nature of the separate offense. D, whether removal or confinement prevented the alleged victim from summoning assistance, although the defendant need not have succeeded in preventing the alleged victim from doing so. E, whether the removal or confinement reduced the defendant's risk of detection, although the defendant need not have succeeded in its objective. And F, whether the removal or confinement created a significant danger or increased the alleged victim's risk of harm independent of that posed by the separate offense. Unless you find beyond a reasonable doubt that the alleged victim's removal or confinement exceeded that which was necessary to accomplish the alleged premeditated first-degree murder, felony murder, or aggravated rape, and their lesser included offenses that was not essentially incidental to it, you must find the defendant not guilty of especially aggravated kidnapping. You will so report on your verdict form. If you have a reasonable doubt as to the defendant's guilt of especially aggravated kidnapping as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of attempted especially aggravated kidnapping, a lesser included offense. The essential elements necessary to constitute attempt or especially aggravated kidnapping had previously been set out in these instructions. Refer to those instructions herein. If you find from the proof beyond a reasonable doubt that the defendant is guilty of attempted especially aggravated kidnapping, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of attempted especially aggravated kidnapping as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of facilitation of especially aggravated kidnapping, a lesser included offense. Facilitation of aggravated kidnapping. The essential elements necessary to constitute facilitation of a felony and especially aggravated kidnapping have previously been set out in these instructions. Please refer to those instructions herein. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of especially aggravated kidnapping, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of especially aggravated kidnapping as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of aggravated kidnapping, a lesser included offense. Lesser included offense of count 8, aggravated kidnapping. Any person who commits an aggravated kidnapping is guilty of a crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1, the defendant knowingly removed or confined another unlawfully so as to interfere substantially with others' liberty. And 2, the defendant possessed or threatened the use of a deadly weapon, to wit, a baseball bat. A removal or confinement is unlawful if it's accomplished by force, threat, or fraud. Force or fraud have previously been defined for you in the instruction on aggravated kidnapping in count 7. Refer to those definitions here. Violence and deadly weapon have previously been defined for you. I think I've already done that. I'm sorry. The definition of bodily injury knowingly, intentionally have been previously defined for you in the instructions of aggravated rape. Refer to those definitions herein. Although the law requires no specific period of time for confinement or distance of removal or confinement interferes substantially with another's liberty, if the time of confinement is significant or the distance of removal is considerable. To find the defendant guilty of this aggravated kidnapping, you must also find beyond a reasonable doubt that the removal or confinement was to a greater degree than that necessary to commit the offense. A premeditated first-degree murder, felony murder, count 3, aggravated rape is charged or included in counts 1, 3, 4, 5, and 6. In making this determination, you may consider only the relevant facts and circumstances of the case, including but not limited to the following factors. A, the nature and duration of the alleged victim's removal or confinement as defendant. B, whether the removal or confinement occurred during the commission of a separate offense. C, whether the interference with the alleged victim's liberty was inherent in the nature of the separate offense. Whether the removal or confinement prevented the alleged victim from summoning assistance, although the defendant need not have succeeded in preventing the alleged victim from doing so. E, whether removal or confinement reduced the defendant's risk of detection and although the defendant need not have succeeded in this objective, and F, whether removal or confinement created a significant danger or increased the alleged victim's risk of harm independent of that posed by the separate offense. Unless you find beyond a reasonable doubt that the alleged victim's removal or confinement exceeded that which was necessary to accomplish the alleged premeditated first-degree murder, felony murder, or aggravated rape was not especially incidental to you, you must find the defendant not guilty of aggravated kidnapping. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated kidnapping, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of aggravated kidnapping as charged in indictment, then your verdict must be not guilty of this offense, and then you shall proceed to determine his guilt or innocence of attempted aggravated kidnapping, a lesser included offense. The essential elements necessary to constitute the attempted and aggravated kidnapping have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of attempted aggravated kidnapping, you'll report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of attempted aggravated kidnapping as charged in the indictment, then your verdict must be not guilty of this offense, and then you'll proceed to determine guilt or innocence of facilitation of aggravated kidnapping, a lesser included offense. Facilitation of aggravated kidnapping. The essential elements necessary to constitute facilitation of a felony and aggravated kidnapping have been previously set out in these instructions. Refer to those instructions herein. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of aggravated kidnapping, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of aggravated kidnapping as charged in the indictment, then your verdict must be not guilty of this offense, and then you shall proceed to determine his guilt or innocence of facilitation of attempted aggravated kidnapping. The lesser included offense of facilitation of attempted, especially aggravated kidnapping. The essential elements necessary to constitute facilitation of a felony, attempted, especially aggravated kidnapping, have previously been set out in these instructions. Refer to those instructions herein. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of attempted, especially aggravated kidnapping, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of aggravated, especially kidnapping, as charged in the indictment, then your verdict must be not guilty of this offense, and then you shall proceed to determine his guilt or innocence of kidnapping, a lesser included offense. Kidnapping. Any person who commits the offense of kidnapping is guilty of a crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1, the defendant knowingly removed or confined another unlawfully so as to interfere substantially with the other's liberty. And 2, the removal or confinement was under circumstances that exposed the other to serious bodily injury. Again, removal or confinement is unlawful if it's accomplished by force, threat, or fraud. Although the law requires no specific time or specific period of confinement or distance of removal, a removal or confinement interferes substantially with another's liberty if the time of confinement is significant or the distance of removal is considerable. To find the defendant guilty of this kidnapping, you must also find beyond a reasonable doubt that the removal or confinement was to a greater degree than that necessary to commit the offense of premeditated first-degree murder. Felony murder and aggravated rape is charged in counts 1, 3, 4, 5, and 6. In making this determination, you may also consider the relevant facts and circumstances of the case, including but not limited the nature and duration of the alleged victim's removal or confinement by the defendant, whether removal or confinement occurred during the commission of a separate offense, whether interference with the alleged victim's liberty was inherent in the nature of the separate offense, D, whether removal or confinement prevented the alleged victim from summoning assistance, although the defendant need not have succeeded in preventing the alleged victim from doing so, whether removal or confinement reduced the defendant's risk of detection, although the defendant need not have succeeded in this objective, and F, whether removal or confinement created significant danger or increased the alleged victim's risk of harm independent of that posed by the separate offense. Unless you found beyond a reasonable doubt the alleged victim's removal
or confinement exceeded that which was necessary to accomplish the alleged premeditated first-degree murder, felony murder, or aggravated rape, and was not essentially incidental to it, you must find the defendant not guilty of aggravated kidnapping. The definitions of bodily injury, knowingly and intentionally, have previously been defined for you in instructions on rape. Refer to those definitions here. Fraud, violence, and force have previously been defined for you in instructions on aggravated kidnapping above. Refer to those definitions here. If you find from the proof beyond a reasonable doubt the defendant is guilty of kidnapping, you shall report your verdict on the verdict form. If you have a reasonable doubt as the defense guilty of kidnapping is charged in the indictment, then your verdict must be not guilty as this offense, and then you should proceed to determine his guilt or innocence of attempted kidnapping, a lesser offense. The lesser included offense of attempted kidnapping. The essential elements necessary to constitute attempted kidnapping has previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt the defendant is guilty of attempted kidnapping, you will so report your verdict on the verdict form. If you have a reasonable doubt as the defendant is guilty of attempted kidnapping as charged in the indictment, then your verdict must be not guilty as this offense, and then you proceed to determine his guilt or innocence of facilitation of kidnapping, a lesser included offense. The essential elements necessary to constitute facilitation of a felony and kidnapping have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of kidnapping, you'll so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of kidnapping as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of facilitation of attempted aggravated kidnapping. Facilitation of attempted aggravated kidnapping. The essential elements necessary to constitute facilitation of a felony, attempt, and aggravated kidnapping have been previously set out in these instructions. Refer to the instructions herein. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of attempted aggravated kidnapping, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilty of facilitation of attempted aggravated kidnapping as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of facilitation of attempted kidnapping, a lesser included offense. Facilitation of attempted kidnapping. The essential elements necessary to constitute facilitation of a felony, attempt, and aggravated kidnapping have previously been set out in these instructions. Refer to those instructions herein. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of attempted kidnapping, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of attempted aggravated kidnapping as charged in the indictment, then your verdict must be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of false imprisonment, a lesser included offense. Yeah, let's go ahead and break for lunch. What do you think? So, you can have a seat. What we'll do is we'll finish this up when you come back from lunch. But during lunch, since you don't have all the law, I've not picked the alternate, we can't start the deliberation.
So when you're eating your lunch, you can't talk to your fellow juror about the case. Everybody agree not to do that? That'd be fine. Thanks for doing that. We'll take I'll let y'all be back here at 1:15, and then hopefully what we'll do is I probably got another 30 minutes to charge it to do. I'll do that. Then we'll pick our alternates, and then 12 jurors can start their deliberation. All right? So see y'all back here at 1:15. You can leave your instructions to stay in the
All rise. Jury, follow me.
Anything from the state before we break for lunch?
No, Your Honor.
Anything from the defense? Okay, see y'all back at 1:15.
Thank you. Have a seat, please. And back to our jury instructions. We're going to start off with the lesser included offense of count 8, which is false imprisonment. Any person who commits the offense of false imprisonment is guilty of the crime. Where you find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1, defendant removed or confined another unlawfully so as to interfere substantially with the other person's liberty. And 2, the defendant acted knowingly. A removal or confinement is unlawful. It's accomplished by force, threat, or fraud. Although the law requires no specific period of time of confinement or distance of removal, a removal or confinement interferes substantially with another's liberty if the time of confinement is significant or the distance of removal is considerable. To find the defendant guilty of kidnapping, you must also find a reasonable doubt that the removal of the confinement was to a greater degree than necessary to commit the offenses of premeditated first-degree murder, felony murder, or aggravated rape, as charged in counts, as include counts 1, 3, 4, 5, and 6. In making this determination, you may consider all the relevant facts and circumstances of the case, including but not limited to the following factors. A, the nature and duration of the alleged victim's removal or confinement by the defendant. B, whether removal or confinement occurred during the commission of a separate offense. C, whether interference with the alleged victim's liberty was inherent in the nature of the separate offense. D, whether removal or confinement of the alleged victim from the summoning assistance, although the defendant need not to have been succeeded in preventing the alleged victim doing so. E, whether removal or confinement reduced the defendant's risk of detection, although the defendant need not to have succeeded in that objective. And F, whether removal or confinement created a significant danger or increased the alleged victim's risk of harm independent of that possessed by the separate offense. Unless you find beyond a reasonable doubt that the alleged victim's removal or confinement exceeded that which was necessary to accomplish the alleged premeditated first-degree murder, felony murder, or aggravated rape that was not essentially incidental to it, you must find the defendant not guilty of aggravated kidnapping. The definitions of bodily injury, knowingly, intentionally have been previously defined for you in the instructions on aggravated rape. You can refer to that in these definitions herein. Fraud, violence, and force have previously been defined as well. If you find from the proof beyond a reasonable doubt that the defendant is guilty of false imprisonment, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant is guilty of false imprisonment as charged in the indictment, then your verdict will be not guilty as to the offense, and then you should proceed to determine his guilt or innocence of attempted false imprisonment, a lesser included offense. The essential elements necessary to constitute attempt at false imprisonment have previously been set out in the instructions. Refer to those instructions herein. If you find from the proof beyond a reasonable doubt that the defendant is guilty of attempted false imprisonment, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant is guilty of attempted false imprisonment as the charge in the indictment, then your verdict must be not guilty as to this offense. Count 9. Conspiracy to commit premeditated first-degree murder. Any person who conspires to commit premeditated first-degree murder is guilty of a crime.
For you find the defendant guilty of criminal conspiracy to commit premeditated first-degree murder, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1. The defendant entered into an agreement with one or more people to commit the offense of premeditated first-degree murder. It is not necessary that the object of the agreement be attained. And 2, each of the parties to the conspiracy had the intent to commit the offense of premeditated first-degree murder, which has been defined for you in count 1. 3, each party acting for the purpose of promoting or facilitating the commission of the offense of premeditated first-degree murder agreed that one or more of them would engage in conduct which constitutes the offense of premeditated first-degree murder. And 4, one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one of the parties to carry out the intent of the conspiracy, and it must be a step towards the execution of the conspiracy. Here for count 9, its lesser included offense intent means a person acts intentionally when it is that person's conscious objective or desire to cause the death of the alleged victim. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed, or the agreement they be completed is abandoned by the person or by those whom the person conspired. The objectives of the conspiracy include but are not limited to escape from the offense, distribution of proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. If you find from the proof beyond a reasonable doubt the defendant is guilty of conspiracy to commit premeditated first-degree murder, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of conspiracy to commit premeditated first-degree murder as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of the conspiracy to commit second-degree murder, a lesser included offense. Any person who conspires to commit second-degree murder is guilty of the crime. Were you find the defendant guilty of criminal conspiracy to commit second-degree murder, the state must prove beyond a reasonable doubt the existence of the following essential elements. Excuse me. The defendant entered into agreement with one or more people to commit the offense of second-degree murder. It is not necessary that the object of the agreement be obtained. And 2, each of the parties to the conspiracy had the intent to commit the offense of second-degree murder, which has been defined for you in the lesser included offenses of count 1. And 3, each party acting for the purpose of promoting and facilitating the commission of the offense of second-degree murder has agreed that one or more of them would engage in conduct which constitute the offense of second-degree murder. And 4, one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is done by one of the parties to carry out the intent of the conspiracy, and it must be a step towards the execution of that conspiracy. Here, intent means the person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed, or the agreement that may be completed is abandoned by the person and by those whom the person conspired. The objectives of the conspiracy include but are not limited to escape from the offense, distribution of proceeds of the offense, and measures other than silence for concealing the crime and obstructing justice in relation to it. If you find from the proof beyond a reasonable doubt the defendant is guilty of conspiracy to commit second-degree murder, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of conspiracy to commit second-degree murder as charged in the indictment, then your verdict will be not guilty as to this offense, and then you shall proceed to determine his guilt or innocence of conspiracy to commit voluntary manslaughter as a lesser included offense. Any person who conspires to commit voluntary manslaughter is guilty of the crime. For you to find the defendant guilty of the criminal conspiracy to commit voluntary manslaughter, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1, the defendant entered into agreement with one or more people to commit the offense of voluntary manslaughter. It's not necessary that the object of the agreement be obtained. And 2, each of the parties to the conspiracy had the intent to commit the offense of voluntary manslaughter, which has been defined for you in the lesser included offenses of count 1. And 3, each party acted for the purpose of promoting or facilitating the commission of the offense of voluntary manslaughter agreed that one or more of them would engage in the conduct which constitute the offense of voluntary manslaughter. And 4, one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one party to carry out the intent of the conspiracy, and it must be a step towards the execution of the conspiracy. Here, intent means a person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. Conspiracy is a continuing course of conduct which terminates when the objects of the conspiracy are completed, or the agreement that they be completed is abandoned by the person and by those whom the person conspired. The objectives of the conspiracy include but are not limited to escape from the offense, distribution of the proceeds of the offense, and measures other than for silence, for concealing the crime, obstructing justice in relation to it. If you find from the proof beyond a reasonable doubt that the defendant is guilty of conspiracy to commit voluntary manslaughter, you will so report on your verdict form. If you have a reasonable doubt as to the defendant's guilt of conspiracy to commit voluntary manslaughter as charged in the indictment, then your verdict must be not guilty to this offense. Count 10, conspiracy to commit aggravated rape. Any person who conspires to commit aggravated rape is guilty of a crime. Were you to find the defendant guilty of criminal conspiracy to commit aggravated rape, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1, defendant entered into an agreement with one or more people to commit the offense of aggravated rape. It's not necessary the object of the agreement be obtained. And 2, each of the parties to the conspiracy had the intent to commit the offense of aggravated rape, which has been defined for you in counts 4, 5, and 6. And 3, each party acted for the purpose of promoting and facilitating the commission of the offense of aggravated rape, agreed that one or more of them would engage in that conduct which constitutes the offense of aggravated rape. And 4, one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one of the parties to carry out the intent of the conspiracy, and it must be a step towards execution of the conspiracy. Here, for count 10, as lesser included offenses, intent means that a person acts with intentionally with respect to the nature of the conduct or to the result of the conduct, when it's the person's conscious objective or desire to engage in the conduct or cause the result. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed, or the agreement that they be completed is abandoned by the person and by those with whom the person conspired. The objectives of the conspiracy include but are not limited to the following: escape from the offense, distribution of proceeds of the offense, measures other than silence for concealing the crime or obstructing justice in relation to it. If you find from the proof beyond a reasonable doubt that the defendant is guilty of conspiracy to commit aggravated rape, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of conspiracy to commit aggravated rape, as charged in the indictment, then your verdict must be not guilty as to the offense, and then you shall proceed to determine his guilt or innocence of facilitation of conspiracy to commit aggravated rape as a lesser offense. Any person who conspires to commit a rape is guilty of a crime. If we find the defendant guilty of criminal conspiracy to commit rape, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1, defendant entered into an agreement with one or more persons to commit the offense of rape. It's not necessary the object of that agreement be obtained or attained. 2, each of the parties to the conspiracy had the intent to commit the offense of rape, which has been defined for you in the lesser included offenses of count 4, 5, and 6. Each party acting for the purpose of promoting or facilitating the commission of rape agreed that one or more persons would engage in conduct which constitute the offense of rape. And 4, one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is done by one of the parties to carry out the intent of the conspiracy, and it must step toward the execution of the conspiracy. Here, for count 10, its lesser included offenses, intent means that a person acts intentionally with respect to the nature of the conduct or the result of the conduct, what's the person's conscious objective or desire to engage in the conduct or cause the result. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed, or the agreement that they may be completed. is abandoned by the person and by those whom the person conspired. The objective of the conspiracy include but are not limited to escape from offense, distribution of proceeds of the offense, measures other than silence, or concealing the crime or obstructing justice in relation to it. If you find from the proof beyond a reasonable doubt the defendant is guilty of conspiracy to commit rape, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of conspiracy to commit rape as charged in the indictment, then your verdict must be not guilty as to the offense, and then you should proceed to determine his guilt or innocence of facilitation of conspiracy to commit rape, a lesser included offense. Any person who conspires to commit aggravated sexual battery is guilty of a crime. For you to find the defendant guilty of criminal conspiracy to commit aggravated sexual battery, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1, the defendant entered into an agreement with one or more people to commit the offense of aggravated sexual battery. It's not necessary that the object of that agreement be obtained. And 2, each of the parties to the conspiracy had the intent to commit the offense of aggravated sexual battery, which has been defined for you in lesser included offenses of counts 4, 5, and 6. Each party acting for the purpose of promoting and facilitating the commission of the offense of aggravated sexual battery agreed that one or more of them would engage in the conduct which constitutes the offense of aggravated sexual battery. 4, one of the parties of the conspiracy committed an overt act that furthers the conspiracy. An overt act is done by one of the parties to carry out the intent of the conspiracy, and it must be a step towards execution. Here, for count 10, its lesser included offenses, intent means a person acts intentionally with respect to the nature of the conduct or the result of the conduct once the person's conscious objective or desire to engage in the conduct or cause the result. Conspiracy is a continuing course of conduct which terminates when the objective of the conspiracy are completed or the agreement that they be completed is abandoned by the person and by those who the person has conspired. The objectives of the conspiracy include but are not limited to escape from the offense, distribution of proceeds of the offense, measures other than silence for concealing the crime, or obstructing justice in relation to it. If you find from the proof beyond a reasonable doubt that the defendant is guilty of conspiracy to commit aggravated sexual battery, you will so report in your verdict form. If you have a reasonable doubt as to the defendant's guilty of conspiracy to commit aggravated sexual battery is charged in the indictment, then your verdict must be not guilty as this offense, and then you should proceed to consider guilt or innocence of facilitation of conspiracy to commit aggravated sexual battery as a lesser offense. Any person who conspires to commit sexual battery is guilty of a crime. For you find the defendant guilty of criminal conspiracy to commit sexual battery, the state must have proven beyond a reasonable doubt the following essential elements. 1, the defendant entered into an agreement with one or more people to commit the offense of sexual battery. It's not necessary that the object of the agreement be obtained. And 2, each of the parties to the conspiracy had the intent to commit the offense of sexual battery, which has been defined for you in lesser included offenses of 4, 5, and 6. Each party acting for the purpose of promoting and facilitating the commission of the offense of sexual battery agreed that one or more of them would engage in conduct which constitute the offense of sexual battery. And 4, one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is done by one of the parties to carry out the intent of the conspiracy, and it must be a step towards the execution of the conspiracy. Here, for count 10, its lesser included offenses, intent means a person acts intentionally with respect to the nature of the conduct or to result of the conduct when it's the person's conscious objective or desire to engage in the conduct or cause the result. Conspiracy is a continuing course of conduct which terminates when the object of the conspiracy is completed or the agreement that they be completed is abandoned by the person and those whom the person inspired. The objectives of the conspiracy include but are not limited to escape from the offense, distribution of proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. If you find from the proof beyond a reasonable doubt the defendant is guilty of conspiracy to commit sexual battery, you will report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of conspiracy to commit sexual battery as charged in the indictment, then your verdict must be not guilty after that offense. Count 11, conspiracy to commit aggravated kidnapping. Any person who conspires to commit aggravated kidnapping is guilty of a crime. If we find the defendant guilty of criminal conspiracy to commit aggravated kidnapping, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1, the defendant entered into an agreement with one or more people to commit the offense of aggravated kidnapping. It's not necessary that the object of the agreement be obtained. And 2, each of the parties to the conspiracy had the intent to commit the offense of aggravated kidnapping, which has been defined for you in count 7. And 3, each party acting for the purpose of promoting or facilitating the commission of offense of aggravated kidnapping agreed that one or more of them would engage in the conduct which constitutes the offense of aggravated kidnapping. One of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by those parties to carry out the intent of the conspiracy, and it must be a step towards the execution of the conspiracy. Here for count 11, it's lesser included offenses. Intent means the person acts intentionally with respect to the nature of conduct or as a result of the conduct when it's the person's conscious objective or desire to engage in the conduct or cause the result. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed or the agreement that may be completed is abandoned by the person or those whom the person conspired. The objectives of the conspiracy include but are not limited to escape from the offense, distribution of proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. If you find from the proof beyond a reasonable doubt the defendant is guilty of conspiracy to commit aggravated kidnapping, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of conspiracy to commit aggravated kidnapping as charged in the indictment, then your verdict must be not guilty as to the offense, and then you proceed to determine his guilt or innocence of conspiracy to commit kidnapping, a lesser included offense. Conspiracy to commit kidnapping. For any person who conspires to commit kidnapping is guilty of a crime. If we find the defendant guilty of criminal conspiracy to commit kidnapping, the state must have proved beyond a reasonable doubt the existence of the following elements. 1, the defendant entered into an agreement with one or more people to commit the offense of kidnapping. It's not necessary that the object of the agreement be obtained. And 2, each of the parties to the conspiracy had the intent to commit the offense of kidnapping, which has been defined for you in the lesser included offenses of count 7. And 3, each party acting for the purpose of promoting or facilitating the commission of the offense of kidnapping agreed that one or more of them would engage in the conduct which constitutes the offense of kidnapping. And 4, one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is done by one of the parties to carry out the intent of the conspiracy, and it must be a step towards the execution of the conspiracy. Here for count 11, as lesser included offenses, intent means a person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed or the agreement that be completed as be abandoned by the person and those whom the person conspired. The objectives of the conspiracy include but are not limited to escape from the offense, distribution for the proceeds of the offense, and measures other than the silence for concealing the crime or obstructing justice in relation to it. If you find from the proof beyond a reasonable doubt that the defendant is guilty of conspiracy to commit kidnapping, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of conspiracy to commit kidnapping as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence of the conspiracy to commit false imprisonment, a lesser included offense. False imprisonment. Any person who conspires to commit false imprisonment is guilty of a crime. For you find the defendant guilty of criminal conspiracy to commit false imprisonment, the state must have proved beyond a reasonable doubt the existence of the following essential elements. 1, the defendant entered into an agreement with one or more people to commit the offense of false imprisonment. It's not necessary the object of that agreement be obtained. And 2, Each of the parties to the conspiracy had the intent to commit the offense of false imprisonment, which has been defined for you in the lesser included offenses in count 7. And 3, each party acting for the purpose of promoting or facilitating the commission of the offense of false imprisonment agreed that one or more of them would engage in the conduct which constitutes the offense of false imprisonment. 4, one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one of the parties to carry out the intent of the conspiracy, and it must be a step towards the execution of conspiracy. Here for count 11, its lesser included offenses, intent means a person acts intentionally with respect to the nature of the conduct or the result of the conduct, unless the person's conscious objective or desire to engage in the conduct or cause the result. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed, or the agreement that may be completed is abandoned by the person and by those whom the person conspired. The objectives of the conspiracy include but are not limited to escape from the offense, distribution of proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice and its relation. If you find from the proof beyond a reasonable doubt the defendant is guilty of conspiracy to commit false imprisonment, you shall so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of conspiracy to commit false imprisonment as charged in the indictment, then your verdict must be not guilty as to this offense. Count 12, abuse of the corpse. Any person who commits the offense of abuse of a corpse is guilty of a crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt that exists of the following essential elements. 1, the defendant did physically mistreat the corpse in a manner offensive to the sensibilities of an ordinary person. And 2, the defendant acted without legal privilege. And 3, the defendant acted knowingly. In a sign where the act was offensive to the sensibilities of an ordinary person, the jury must avoid subjective personal and private views and evaluate the sensibilities of a hypothetical or average adult person, applying the collective view of the adult community as a whole. Legal privilege means a particular benefit or advantage created by law. Ordinary person means a person of ordinary care and diligence in relation to a particular thing. Here, knowingly means a person acts knowingly with respect to the conduct and the circumstances surrounding the conduct when the person is aware of the nature of the conduct or the circumstances that exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Here, intentionally means a person acts intentionally with respect to the nature of the conduct or the result of the conduct when it's the person's conscious objective or desire to engage in the conduct or cause the result. If you find from the proof beyond a reasonable doubt the defendant is guilty of abuse of the corpse, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of abuse of the corpse as charged in the indictment, then your verdict must be not guilty. And as to this offense, then you shall proceed to determine his guilt or innocence of attempted abuse of the corpse. Attempted abuse of the corpse. The essential elements necessary to constitute attempt and abuse of the corpse have previously been set out in these instructions. Refer to those instructions here. If you find from the proof beyond a reasonable doubt that the defendant is guilty of attempted abuse of the corpse, you shall so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of attempted abuse of the corpse as charged in the indictment, then your verdict must be not guilty as to that offense, and then you should proceed to determine his guilt or innocence of facilitation of abuse of the corpse, a lesser included offense. The essential elements necessary to constitute facilitation of a felony and abuse of the corpse have previously been set out in these instructions. Refer to those instructions herein. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of abuse of the corpse, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of the facilitation of abuse of a corpse as charged in your indictment, then your verdict must be not guilty as to this offense. Tampering with evidence, count 13. Any person who tampers with evidence is guilty of a crime. For to find the defendant guilty of this offense, the state must prove the essential following elements. 1. The defendant knew an investigation was pending, and 2. The defendant destroyed or concealed a thing with intent to impair its ability as evidence in the investigation. Conceal means to prevent disclosure or recognition of or place out of sight a thing. Destroy means to ruin the evidentiary value of a thing. Thing means an object or entity not precisely designated or capable of being designated. Here, knowingly means a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct, when the person is aware of the nature of the conduct or that the circumstance exists. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Here, intentionally means a person acts intentionally with respect to the nature of the conduct or to the result of the conduct, which the person's conscious objective or desire to gauge in the conduct or cause the result. If you find from the proof beyond a reasonable doubt that the defendant is guilty of tampering with evidence, and as the defendant is guilty of tampering with evidence as charged in the indictment, then your verdict must be not guilty. Let me read that over again, if you don't mind. If you find from the proof beyond a reasonable doubt the defendant is guilty of tampering with evidence, you will so report on your verdict on your verdict form. If you have a reasonable doubt as the defendant is guilty of tampering with evidence as charged in the indictment, then your verdict must be not guilty as to that offense, and you shall proceed to determine his guilt or innocence of attempted tampering with evidence as a lesser included offense. The essential elements necessary to constitute attempt at tampering with evidence have previously been set out in these instructions. Refer to those instructions herein. If you find from the proof beyond a reasonable doubt that the defendant is guilty of attempted tampering with evidence, you will so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of attempted tampering with evidence as charged in the indictment, then your verdict must be not guilty as to this offense, and then you should proceed to determine his guilt or innocence on the facilitation of tampering with evidence, a lesser included offense. The essential elements necessary to constitute facilitation of a felony and tampering with evidence have previously been set out in these instructions. Refer to these instructions herein. If you find from the proof beyond a reasonable doubt the defendant is guilty of facilitation of tampering with evidence, you will so report your verdict on the verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of tampering with evidence as charged in the indictment, then your verdict must be not guilty as to the offense. Then you shall proceed to determine his guilt or innocence of facilitation of attempted tampering with evidence, a lesser included offense. The essential elements necessary to constitute facilitation of felony, attempted tampering with evidence have previously been set out in these instructions. Refer to those instructions herein. If you find from the proof beyond a reasonable doubt that the defendant is guilty of facilitation of attempted tampering with evidence, you shall so report your verdict on your verdict form. If you have a reasonable doubt as to the defendant's guilt of facilitation of attempted tampering with evidence as charged in an indictment, then your verdict must be not guilty as to that offense. This is labeled order of consideration. In reaching your verdict, you shall first consider the offense charged in count 1. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense, or have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense, in order from greatest to least with that count. You shall not proceed to consider any lesser included offense until you first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that count, you shall return a verdict of not guilty and then proceed to the next count and follow the same procedure as to each count of the indictment. The crime charged in each count of the indictment is separate and distinct. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charged must be stated in your verdict. During the trial, you heard the expert testimony of Dr. Dorinka Malaska Hawkson. Probably mispronounced that name, so I apologize to the doctor, who was described us as an expert in the field of forensic pathology. We also heard from TBI Special Agent Douglas Williams, who is an expert in the field of forensic pathology. I didn't say that right. Special Agent Douglas Williams, who was described as an expert in the field of digital forensic, and TBI Special Agent Jennifer Millsaps, who was described to us as an expert in the field of forensic biology and serology. The rules of evidence provide that scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining the fact and issue. A witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. In giving an opinion, an expert witness may have testified that he or she took into consideration certain statements made by other persons. Because the statements were made outside the courtroom, they may be used only for you in evaluating the expert witness's testimony and cannot be relied upon as proof of the matter, proof of truth of the matters asserted in these statements. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept that opinion. The same as with any other witness, it's up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinion were based on sound reason, judgment, and information. You're to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. The guilt of the defendant, as well as any facts required to be proved, may be established by direct and circumstantial evidence, or both, or by both combined. Direct evidence is defined as evidence which proves the existence of a fact in an issue without inference or presumption. Direct evidence may consist of testimony of a person who has perceived by means of his or her senses the existence of a fact sought to be proved or disproved. Circumstantial evidence consists of proof of collateral facts and circumstances which do not directly prove the fact in issue, but from which that fact may be logically inferred. It is your duty to decide how much weight to give to the direct and circumstantial evidence. The law makes no distinction between the weight that you should give to one another, or say that one is better evidence than another. You should consider all the evidence, both direct and circumstantial, and give it whatever weight you believe it deserves. You are the exclusive judges of the credibility of witnesses and the weight to be given to their testimony. If there are conflicts in the testimony of different witnesses, you must try to reconcile them if you can, without hastily or rashly concluding that any witness is sworn falsely. For the law presumes that all witnesses are truthful. In forming your opinion as to the credibility of a witness, you may look to the proof of any, if any, of his or her general character, the evidence of any of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters, if any, are shown, and all the evidence in the case tending to corroborate or to contradict him or her. The defendant is not taking the stand to testify as a witness, but you shall place no significance on that fact. The defendant is presumed innocent, and his burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. A witness may be impeached by proving that he or she has made some material statements out of court which are at variance with his or her evidence on the witness stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing that witness's credibility, and not as substantive evidence of the truth of the matter asserted in such out-of-court statements. Further, a witness may be impeached by careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statement of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness has thus been impeached, the jury has the right to disregard his or her testimony evidence and treat it as untrue, except where it's corroborated by other credible testimony or by facts and circumstances proved on the trial. The court charges you that the identity of the defendant must be proven in the case on the part of the state to your satisfaction beyond a reasonable doubt. In other words, the burden of proof is on the state to show that the defendant now on trial before you is the identical person who committed the alleged crime with which he is charged. And considering the identity of a person, the jury must take into consideration all the facts and circumstances in the case. The court further charges you that if you're satisfied from the whole proof in the case beyond a reasonable doubt that the defendant committed the crime charged against him, and you're satisfied beyond a reasonable doubt that he has been identified as the person who committed the crime charged, then it would be your duty to convict him. On the other hand, if you're not satisfied with the identity from the proof, or you have reasonable doubt as to whether he has been identified from the whole body of proof in the case, then you should return a verdict of not guilty. The prosecution has presented a witness who claims to have been a participant with the defendant in the crime charged. While you may convict upon the testimony alone, you should act upon it with great caution. Give it careful examination in the light of the other evidence. You are not to convict upon the testimony alone unless you're convinced beyond a reasonable doubt that it is true. If from the proof you find that the witness Rebecca Dishman has committed a bad act other than that for which she is pled to with threats related to jealousy in the jail, you may not consider such evidence to prove her disposition to commit such a crime. The evidence may be only considered by you for the limited purpose of determining whether it provides a motive, that is, such evidence may be considered for you if it tends to show a motive of the witness for the commission of the offense charged here, or b, the witness's intent, that such evidence may be considered by you if it tends to establish the witness actually intended to commit the crime charged here. Such evidence of other bad acts, if considered for you for any other purpose, must not be considered for any other purpose other than that specifically stated. The court instructs you there is evidence of an oral written statement given by the defendant in this case. You may take it into consideration with all other facts and circumstances proved in the case. And considering the statement is for you, the jury, to say what weight you would give that statement. You may believe any part of the statement or disbelieve any part of it. You may believe the whole statement or disbelieve it in its entirety. Evidence has been introduced in the trial or statements by the defendant made outside the trial to show an admission against interest. An admission against interest is a statement by the defendant which would acknowledge the existence of some truth or fact necessary to be proven to establish the guilt of the defendant, or which tends to show the guilt of the defendant or is evidence of some material fact, but not amounting to a confession. While this evidence has been received, it remains your duty to decide in fact if such statements are true. If you believe a statement was not made by the defense, you should not consider it. If you decide the statement was made by the defendant, you must judge the truth of the facts stated, and so determine, consider the circumstances under which the statement was made. Also consider whether any other evidence before you tends to contradict that statement in whole or in part. You must not, however, arbitrarily disregard any part of the statement, but rather you should consider all the statement you believe was made and is true. You are the sole judges of the weight. You are the sole judges of the weight should be given to such a statement. If you decide a statement was made, you should consider it with all the other evidence in the case and determine the defendant's guilt or innocence. Before the defendant can be convicted of any degree of homicide, the state must have proven beyond a reasonable doubt that the death of the deceased was proximately caused by the criminal conduct of the defendant, by the conduct of another for whom the defendant is criminally responsible, or both. The proximate cause of a death is that cause which, in a natural and continuous sequence, unbroken by any independent intervening cause, produces the death, and without which death would not have occurred. The defendant's conduct need not be the sole or immediate cause of death. The acts or omissions of one or two persons may work concurrently to approximately cause the death, and in such case, each of the participating acts or omissions is regarded as a proximate cause. It is not an offense if the negligent conduct of the deceased may also have been a proximate cause of death. However, it is a defense to homicide if the proof shows the defendant the death was caused by an independent intervening act or omission of the deceased, or another which is likely to happen. However, if in the exercise of ordinary care the defendant should reasonably have anticipated the intervening cause, that cause does not supersede the defendant's original conduct, and the defendant's conduct is considered the proximate cause of death. It is not necessary that the sequence of events or particular injury be foreseeable. It's only necessary that the death fall within the general field of danger which the defendant should have reasonably anticipated. If some other circumstances cause the victim's death unrelated to defense actions, that would be a defense to homicide, unless the circumstances was the natural result of the defendant's act. If you find that the defense acts, if any, did not unlawfully cause or contribute to the death of the deceased, or if you've had a reasonable doubt as to this proposition, then you must find him not guilty. Any attempt by a person to conceal or destroy evidence is circumstantial which, when considered with all the facts of the case, may justify an inference of guilt. While that inference is by no means strong enough by itself to warrant conviction, yet it may become one of the series of circumstances from which guilt may be logically inferred. Whether the evidence presented proves beyond a reasonable doubt that the defendant so acted is a question for your determination. If this fact is proven, this fact alone does not allow you to find the defendant guilty of the crime alleged. However, since an attempt by a defendant to destroy or conceal evidence may be caused by a consciousness of guilt, you may consider this fact. If it is so proven together with all of the other evidence which you decide the guilty or innocent of the defendant. On the other hand, a person entirely innocent of a particular crime may attempt to destroy or conceal evidence, and this may be explained by proof offered or by the facts and circumstances of this case. Concealment or destruction of evidence of a crime is not proof of premeditation. When there was an attempt to destroy or conceal evidence by the defendant, the reason for it and the weight to be given it are all questions to be determined by you. The court has charged the jury concerning an inference that the jury may make in regard to certain evidence. However, the jury is not required to make this inference. It is the exclusive province of the jury to determine whether the facts and the circumstances shown by all the evidence in this case warrant the interference which the law permits the inference which the law permits the jury to draw. The inference may be rebutted by direct or circumstantial evidence, or by both, whether it exists in the evidence of the state or is offered by the defendant. Although the defendant is not required by law to do so, when the defendant offers an explanation to rebut the inference raised, you should consider such explanation along with all the evidence to determine not only the correctness of the inference, but also the reasonableness of the defendant's explanation. You're not bound to accept either the inference or the defendant's explanation. The state must prove beyond a reasonable doubt every element of the offense before the defendant can be found guilty. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reach an agreement if you can do so without bias to individual judgment. Each of you must decide the case yourself, but do so after an impartial consideration of evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors, or for the mere purpose of returning a verdict. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside the jury deliberation room. You may not use any electronic device or media, telephone, cell phone, smartphone, iPhone, computer, internet service, text, instant messaging service, internet chat room, blog, website, Facebook, LinkedIn, YouTube, Snapchat, Instagram, Google, Twitter, or any other social media to communicate to anyone any information about this case or conduct any research about the case until you return your verdict and the trial's concluded. In addition, the 12 jurors may not communicate in any way at any time prior to the conclusion of these proceedings with the alternate jurors who will be selected at the conclusion of these instructions. You will have no credits or simply or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality, as you think justice and truth dictate. When you retire to the jury room, you'll first select one of your members as the foreperson who will preside over your deliberations. When you've reached a verdict, you'll knock on the door there and tell the deputy you've reached a verdict, and then he'll bring us on the courtroom and your foreperson will deliver the appropriate verdict form. If you find that the state has proven the defendant guilty beyond a reasonable doubt, then you should find him guilty. On the other hand, if you find the state's not proven beyond a reasonable doubt the defense guilt, or if you have a reasonable doubt as to his guilt, then you must find him not guilty. You'll be provided with forms of all possible verdicts in this case. The jury will complete the appropriate verdict form, and the other verdict form will be left incomplete and unsigned, and you will receive these verdict forms. Let me just briefly show you one of them so you kind of get an idea of what it is. For example, on the first count of premeditated first-degree murder, remember I listed all those lesser-included offenses? So, for example, it says only check one, guilty of premeditated first-degree murder. If you have a unanimous verdict that you cannot reach a verdict on that, then you have to consider the second one. And we go all the way down. And the last one is not guilty. That's K. And the foreperson will sign each one of those. And I've got one of those for each count. So we need to fill those out. Now our procedure is a little bit different since this could be, not guaranteed, could be something that the jury has to do sentencing on. So what I'm going to do is just say I'm going to draw out the four alternates. One of the deputies is going to take the four alternates out. And the four alternates will take their jury notebook with them, and then they'll just leave those in my office. Nobody's going to look at them. They'll be protected for you in case you need to come back. And the reason I have four alternates is, and this has happened before in Tennessee, one of our original 12 gets sick, and I have to replace them, or maybe two or three of them, so I have to replace them. So I'm not willing to let the alternates go. So my four alternates that I keep here, this is important because we're going to probably go until Monday on this before we come back and do other stuff if we've got to do sentencing. My four alternates cannot discuss the case among themselves, what we've heard, what the law is, anything like that. Can't talk about that. And number two, they cannot have any contact with the 12 jurors. They cannot come around them. They can't talk to them. And my deputies will make sure of that. So that's difficult, right? That's challenging. So, and we'll work on the rooms at the hotel, but be prepared. They're going to keep these four away from the 12. And then we'll go into the next phase, and then we'll see what happens with the alternates then. Everybody understand that? Anybody got any questions about it? Okay. All right. So let's see what our alternates are. My first alternate is juror right here. My next alternate is let me hold on to that one for a second, and I'll tell you why in just a second. My next alternate is well, the interesting thing was about I couldn't tell if this was a 9 or a 6. So that's the reason I went away. Well, the next number I drew was a 6. So 9 and 6, you both are alternates. Where's 9? Where's 6? Okay. All right, next alternate is 3. Okay, so everybody rise, and we'll let our alternates go out with our deputy. And you can put their jury instructions and their notebook in our office. Okay? So my alternates are excused. And go with this handsome gentleman right here.
Judge, make sure the alternates understand they still keep talking about it.
I've already told them that once. Don't talk about it.
Twice a month. All right, everybody else can have a seat, please. Now, in just a minute, we're going to begin our deliberations. Let me tell you a little bit about that. I'll send the verdict form back there with you. I'm going to send these exhibits back with you as well. In the event you want any of these CDs or this flash drive played for you all, just knock on the door and tell the officer, and then we'll make the accommodation for y'all to hear that again, or if you want it played, but that's your call. But you'll have the other exhibits in there. I'm not going to send back the stuff in the bags, but like pictures and things like that, I'm going to send all those back. Now, saying that once y'all hit that door, y'all are now in charge. And so when you take breaks, it's up to y'all when you want to take a break. But now let's say 2 or 3 of y'all say we want to take a break and we want to go outside and smoke. Okay? 2 or 3 can go do that, but you can't go out there and talk about the case. And the 9 that are still in there can't talk about the case. We can only deliberate when all 12 of us are together. I'm probably going to let y'all work to about 5:30 or 6 tonight. If you don't have a verdict by then, I'm probably going to let you go to dinner, and then we'd start back on Monday morning. And that'll be challenging, right? Because between now and then, you can only deliberate in that room when all 12 of y'all are there. And so, so that means tomorrow, you all, even if we reach something today, depending on what the punch, or depending if you're going to do sentencing, y'all cannot talk about the case tomorrow at the hotel. You can't talk about it at dinner or breakfast or lunch. The only time we can talk about the case, the evidence and the verdict, is in that room. Everybody understand that? Can everybody do that for me? It's really important. Raise your hand if you can do that for me. Okay, I'm counting on y'all. This is critical that we do this correctly. I was kind of waiting for the officer. Can you see if the jury can go back in its deliberation room yet? And we'll wait just a second. Anybody got any questions about? And if you, I'm not sure it was in the instructions. If you have a question that arises that you need to ask me, all you do is write on a piece of paper, knock on the door, and give it to the officer. But understand, I can only answer questions about the law, and I gave you what the law is. So that's all I can answer. I can't answer about facts or anything like that. So it's very limited about what I can answer. So if you have a question about the law, you can write it down, but understand I'm very limited on that. So around 5 or 5:30, I'll probably bring y'all back in here if you've not reached a verdict by then and say, okay, we're going to break for the evening. We ready? Okay. Thank y'all for participating in this. Everybody rise, please.
Jury, follow me.
Thank you. Have a seat, please. If you leave the courtroom, if you can just leave your phone number with one of the officers up here so we can call you if we need you. Would y'all like to take a break and then maybe go ahead and do our witness impact statements? Go ahead and get that done, or do y'all? I'm sure you're tired. If you'd rather me wait on doing that, I'll do that. Whatever's easier for y'all.
I'll check in with the family right now, so I'm making fun of
Okay, I've got 3, and the way I do it is I ask the family to come up here. I put them under oath. I get them to read their statement, and I found this is better to do it this way because they know exactly what they're saying, and then there's some things I can allow and not allow in the victim impact statements, and so we can go ahead and take care of this before the jury comes back with a determination. So I'll do that without objection to that.
But I don't, let's see, the first one,
So Judge, I'm sorry, just so I understand, this is kind of like a preview of what we're sentencing?
yeah,
Okay.
yeah, except it's really not it's what's gonna be.
Yes,
It's the
that's-
reality
I
of
was
what's,
confused for a second about what was
right.
happening. So-
Does that make sense?
Yes, sir. Thank
Okay,
you.
But it's for you to gauge whether there is something objectionable.
correct. That's one reason, and the other reason is, yeah, just to make them, I found writing it out makes it better.
Absolutely.
So do y'all wanna try this? I think my first one I've got is it Beverly? Beverly, you wanna come up here and read this to me? Just come up here, please, ma'am. Good afternoon, how are you? Good. If you'll raise your right hand for me, swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Good. So the purpose of this is, I appreciate your writing for me, okay? But there's some things I can allow and not allow by law. And so I don't want to do anything to mess this up.
Yeah.
Okay, so I'll let you read this into the record, and then we'll see if anybody's got any objections, or if I suggest we leave something out. Okay?
I need the verdict form.
Oh, you're right. Sorry. My bad. Thank you. Just have a seat right there, please, ma'am. And if you'll say your first name and last name and spell them both. What's the way, just say that he closes that door.
Okay.
Got it. Go ahead, ma'am.
Beverly Jeffers, Beverly Jeffers.
Thank you very much. If you'll read your statement for me.
Your Honor, I wanted to thank you for allowing me to speak on behalf of our family. Our lives have forever been changed. It is always hurtful to lose someone you love, but it is a different kind of hurt and pain to lose someone you love the way our family lost Jennifer. We didn't just lose Jennifer, she was taken from us. When Jennifer went missing, we all looked all over town for her. Gail, Mill, David, and Brittany looked on the south side of Knoxville, and the rest of us took the north side. We looked for her not just for a day or two. We looked for her for months, day after day. Her grandmother who she called Mom, would call me almost every day to ask if I had seen Jennifer. It was so hard on us. We knew Jennifer wouldn't go for days and not contact me or one of us. Then on August the 6th, 2020, Patty, Jennifer's mother, received a call no mother should ever have to get. They found Jennifer. Patty was so devastated. When she called me, I couldn't understand what she was saying. Then when I finally did understand, I, like the rest of our family, went into complete shock. The most awful thing that could happen to a person and their family did happen. Jennifer was murdered. Jennifer, who was a mother, a daughter, a granddaughter, a sister, a niece, and a cousin. Her mother, Patty, didn't make it through the loss and devastation. She died with a broken heart. Before Patty passed away, she asked myself and the other ladies here with me today to promise her we would be here in court every day for her and Jennifer to show Jennifer was loved, is loved, and forever will be loved and missed. Thank you, Your Honor.
Very good. You honored Jennifer by doing that. Don't you think? And you made your promise. You carried out your promise. That's what we're supposed to do, right?
Yes.
Okay, good job. Thank you. I'll take it. And right now, I don't see anything objectionable in that, but I'll talk to the attorneys. If I find anything objectionable, I'll just draw a line through it.
Okay.
Is that okay?
Yeah.
Very good.
Thanks.
Great job. Let's see, next I have, is it Brittany? What? I don't. And this is Ms. Payne? Okay. Ms. Payne, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. And if you'll say your first name and last name and spell them both for me.
Brittany Payne. Can you hear me good?
Yeah, you good?
Brittany Payne. BrittaneyPayne.
And Ms. Payne, I've reviewed this. I've read it. Perfect. Very good job. You honor your friend. The only thing I feel like I should strike is down there where it says
Yes.
evil is real. And I understand you feel that way, and I'm not diminishing that at all. But that may be inappropriate, and I don't want to do anything to mess this up. Okay? So I'm going to draw a line through this. So when you have the opportunity to read this in front of the jury, don't want you to read that. Okay? So will you read this for me?
Yes, sir. Oh, sorry. Jennifer was my first cousin, but we grew up as sisters. I love Jennifer with all of my heart. Losing her has really hurt me. I can't think straight. I have nightmares. Sorry. I have nightmares. I can't sleep right. And this past week, I can't even eat right. I can't listen to songs without thinking of her. It hurts me to know that I will never see her again. I'll never hear her voice again, or see her smile, or hear her laugh. It absolutely kills me that I didn't get to tell her goodbye. Knowing I'll never get these phone calls or messages ever again destroyed my heart. My whole world changed, turned upside down. I'll never look at this world the same again.
Thank you, ma'am. And I've noticed, I've seen you on court every day. And I know you're not here just to see me. You're here to honor your friend or your sister.
Yes.
And so that's a great thing. And you've done that. You've been successful in that. And I can't help but think that she's not pleased that her friends are here lining up for her.
Yes.
Good job. Thank you. You can step down. And next is Jennifer Gale Paxton.
No, Your Honor, this will be Michelle, I believe is.
Oh, I'm sorry, I just read her
her
name.
last name, McMahon.
You're right. Where's Michelle?
You
Okay.
should probably have her sign that with her name.
She did. That's all right. And Michelle, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. If you'll have a seat and tell me your first and last name and spell them both.
Michelle, Michelle, McMahon, Mcmahan.
Okay. And in these victim impact statements, I have to be careful. We can't say anything that would get the jury motivated. Does that make sense?
Yes.
So I'm striking, and when I do this, I'm not being disrespectful to you or your feelings at all.
I understand.
You do? Okay, great. So I'm striking the line that says, I feel that this directly led to her befriending the monster who sits at the defendant's table. Let's see what else we've got here. And then I'm going to strike out the line that says, and I'm not saying this didn't happen, okay? Because I think this is Jennifer's mom that struggled. I think that's what you're saying.
Mm-hmm.
She struggled to understand how not just one, but two people, that evil could be so cruel with disregard for another human life. Okay, so I'm going to strike that, not being disrespectful to you at all, but just making sure I don't have an issue to have to do this again. And so what's your relationship to Jennifer?
I was her mother's first cousin.
Okay. All right. I can't say I got it all, but if you'll read that to us, please, ma'am.
I'm Michelle, first cousin to Jennifer's mother, Patricia. First, I'd like to tell you about Jennifer. She was kind and loving. She cared about other people, even strangers. She grew up with a tough life, as many of us did. The difference between her and us is that she never seemed to make peace and get past the hardships of her childhood or upbringing. She never knew her natural father, and partially, I think that distorted her view of what a typical family unit should be. I believe that this led to her making a series of poor decisions in her own life, including the men she chose to try to build a family with. She longed to have a typical, normal American family. She trusted too easily and too much. Jennifer's mother tried the best she knew how in raising Jen, but in her own words, she made a ton of mistakes, especially with Jennifer. Patty was desperate for Jennifer to not make the same mistakes that she had made herself, like becoming a mother at just 15 years old. Because of this, she was way too hard on Jennifer. Again, her words. Not allowing her to have friends. She wasn't allowed to play in the neighborhood like her brothers or hang out with others after school unless it was with family. This is why Jennifer lovingly clung to her grandmother. She felt loved with her. She was allowed to be more of a child with a normal life when she was with her. So naturally, Jennifer had more of a mother-daughter relationship with her than she did with her mother. Jennifer was also a middle child and the only girl to her mother, Patricia. When Jennifer went missing, it didn't go unnoticed by her family, even though she had become part of the homeless community. Many of us searched for her for months, as well as looking at every person we passed as we went about our daily lives, hoping to spot her somewhere, as we always had in the past. Patty, like many other parents of addicts, was terrified of getting that call or knock on her door to tell her that Jennifer had overdosed and was gone. That call came in August of 2020, only it was much more horrifying than she could have imagined. I spent much of the time after Jennifer went missing with her mother until her passing, only 16 months later. She suffered finding out Jennifer's demise after 9 months of searching. Patty was in poor health, but was haunted by the things we were told by investigators of what those people did to her daughter. She blamed herself. She stated and questioned regularly how if she had been a better mom, or if she had tried one more time to help her, if she could have prevented what happened to Jennifer. She thought Jen fell victim because maybe she didn't feel loved enough, or because she had been so hard on her in her life. Patty had nightmares every night of Jennifer crying out in pain or for mercy. She imagined Jennifer begging them to stop and let her just come home to her family. Patty continued in church looking for comfort and trying to find understanding of what led to Jennifer to get in the car. Patty died in the hospital, still crying and suffering over what happened in the Finnegan Dishman home those 4 or 5 days. Patty had battled health issues for years, but after losing a second child in such a horrifying manner, she had just given up. She was tired. Tired of regret. Tired of the nightmares, the day thoughts. Tired of suffering and missing her daughter, Jennifer Gail Paxton.
I may have to take some things out,
I understand.
but I'll work on that. And, you know, it's hard to understand addiction. I worked with a drug court for about 14 years, and I came to discover that addiction is like cancer. And when you have cancer and it comes back, we don't say you didn't work hard enough in your rehabilitation. And so that's what happens with addiction. It just keeps coming back. And I hope that, I don't know where you are faith-wise, but this is just our temporary home. That's why there's bad things that happen.
I agree.
But good things, there's good things. And Jennifer's in a lot better place.
With her mother.
Not addicted anymore, not hurt anymore, not lived under a bridge.
Amen.
She's on top of the bridge, right?
Yes.
Yeah. So celebrate that. Celebrate those wonderful memories that you have. And when the DA talked about her dancing, I love that. What a great memory of somebody dancing with joy. And that's probably what she's doing while we're struggling through this.
I agree.
Okay.
Thank you.
All right, so I need to make the next exhibit. Here's my jury instruction. Madam Court Porter, will you make that the next number exhibit? And I'll go through and edit this some more. I didn't catch everything I should have caught. And I'll show it to council before we do the victim impact statement so y'all can look at it again. Anything else for the state I need to do?
Just for the record purposes, I brought over the laptop, and if you wanted to look at that to just ensure you're satisfied there's nothing on it.
I'm satisfied, but I'd like you to.
We discussed it. It is a computer that's provided for the purpose of looking at CC material, so it cannot be networked. And for any files that were on it, I've deleted it, and the quick access. So you would never be able to open it anyway since the file's deleted, but you can't even see the file path name that was on there, and emptied the recycle bins.
We plan on staying around, you go back to the office?
I'm going to be in the office. I could leave this here.
Okay.
The password is
And
on
if we can't figure it out, we need your phone number to call and say how to turn the thing on. Okay.
Thank you, Judge.
Anything else I can do? Okay.
Mayor.
And then I think we've still got a motion in limine in regard to the aggravators.
Judge, I misspoke. That's going to be a proposed jury instruction. It's yes, sir.
Later.
Yes, sir.
Okay. So yeah, whenever you can get that to me, I don't need it right now, but sometime I'll need it.
Yes, sir.
Okay. All right. And so if y'all leave, just leave your phone number with one of the officers or with Miss Jones, and we'll call you if we get a verdict or if we have a question. That's normally what's going to happen. I get a question next. Okay. All right. Thank y'all very much.
Thank you.
And we're bringing the computer in there. Ask that they would like a copy of the indictment. So let's think about this for a minute. Looking at Brother Ward's book, it says, let me tell you what it says here. Accordingly, whether to send the indictment into the jury room for use during deliberations appears to be a matter for the trial court's discretion. As a general rule, sending the indictment to the jury room is not error so long as the jury is instructed that the indictment is not to be considered as evidence in the case. So, options are bring them in here, say you've asked for a copy of the indictment, I'm going to give it to you, but then I'd instruct them it's not evidence and not to be considered as evidence. Just so if I'm going to do that, then I don't see the need for them to have the indictment. There's no, unless y'all can convince me otherwise, there's no relevance to it. I mean, I can understand, want to see what the charges are, I guess, or I don't know why they want it, but let's say that they want it, and I tell them they can use it as evidence. What's the relevance of it going back?
It's the state's allegation, so I would ask for an instruction that if you're going to consider it, you can only consider it as an allegation.
Well, no,
Well, I mean, that's what you're saying, when it's not used as evidence.
Right, or not. I mean, I don't guess I have a feeling one way or the other. What do you think?
Supplemental jury instruction.
They did.
Yeah.
You could allow the state to reread the indictment to them
Right.
and not send it back, if that's what
And
they
then give it-
prefer.
And then give the instruction.
Yes.
So the only instruction, that's maybe let you reread the indictment, but then I would just reread the instruction I've already given, saying it's not to be considered as evidence.
That's a fine compromise.
I don't really see.
Another alternative, Judge, would be just to pass a note back saying that the indictment is embodied within the instructions the court's already provided, and
I can do that.
it's over. Because when you bring the jury in, every time you do, Judge, they're subject to outside influence, facial expressions of people, the defendant's
Well,
posture, all of those things.
Yeah, I'm not hesitating to bring the jury back in. I just don't want, like I said, I don't want to add to the confusion.
If they want to see it and they're obviously interested in it, I think the compromise might be the best way to go and just read it to them and say it's not evidence.
With the
And
instruction.
we'll sit here mute while you do that.
And is the court going to read it or the state would?
State.
State, yeah, okay.
In my discretion, let me think about it for a minute.
Yes, sir.
I'll be right back.
Yes, sir.
Okay?
I'll be here.
Thank you. So, but you can go ahead and get it ready just in case. I've got dinner coming for them at 6, so time to come home. I'll give instructions not to talk to anybody, and then tell them we'll start back Monday probably at 8:30. Tell them to come here, give me about 8:15, bring them back in here, tell them y'all start deliberating. But you can't deliberate till I tell you to. We good?
Yes, sir.
Thank you.
And Judge, if you want to bring the 12 at 8:15 and then have the
So these are 4? Yes. Good. All rise, please. All rise. Our 4 jurors, have a seat right up here, please. Thank you. Have a seat. Hello, folks. Thank y'all for your patience and stuff. So what we're going to do is they're going to take y'all to dinner tonight. So we get to do that. Remember not to speak to anybody. You 4 cannot talk about the case or have deliberations or anything like that. And I need to do that just in case I've got to put one of y'all in that 12. And I draw the name out, so I don't know who it would be. So we'll do it that way. On Monday, they're going to bring y'all in a little bit later, since I don't need you here at 8:15. So they're going to probably bring y'all in at 9, and then we'll just kind of go from there. But I appreciate your patience, and hope you have a good time tomorrow. I think they told me they may take everybody to a movie. If they do, they'll put y'all in a separate row and keep them in a separate row. But just help me, y'all stay away from them. Okay? All right, everybody rise, please. Hope y'all have a nice evening. I'll see y'all on Monday at 9. We ready to bring that over? Yep. Thanks.
I just now remembered you.
Is that what you like? Take your seat, please. So they've ordered your dinner and gone to pick it up. So I need y'all to stop deliberating for today. Tomorrow, I don't know what all they're going to do. They mentioned a movie. They mentioned going to the park. I don't know what they're going to do, but I trust them because they want to do what's best for y'all. I'll remember my instructions to you. Y'all cannot deliberate. 2 of y'all can't go off and talk about the case. We can only deliberate when all 12 of y'all are in that room, or hopefully we find you a more comfortable room. So that's our only places to talk about the case. And that's really, really, really important. So please help me accomplish that goal. We'll start on Monday. I'm gonna get them to bring y'all back about 8:15, so we can start at 8:30 and maybe get a full day in of deliberation and try to get and see if we can get this going or get it done. But I appreciate your effort so far, and y'all done great so far. Just remember my instructions to you: don't talk to each other about the case. Everybody understand that? Anybody got any questions about anything? Well, have a good Saturday night and have a blessed Sunday, and I'll see you on Monday morning at 8:15. All right? Okay, everybody rise, please.
All rise. Jerry, follow me.
Thank you. Anything for the state I need to do or did get done? Anything for y'all? Okay, so I'll see y'all on, I'll bring them back in here probably about 8:30 on Monday morning, tell them they can start their deliberations then. Okay?
Thank you.
Thank y'all very much.
Thank you.